This photo is of the staff and pupils of the small boys' boarding school that my father became headmaster of when it was restarted in 1948. The school had been requisitioned by the RAF during the war. The trustees decided they'd set it up again, and my father was appointed the first headmaster. So there is my father, and there is my mother, who ran the boarding house at that stage for him. It's very great sadness to the three of their daughters that the school closed in the 1990s because both of our parents put so much into it. This is a photograph of the proudest day of my professional life. It's the day that I was sworn in as a Lord of Appeal in Ordinary, the first and regrettably the only woman ever to have had that post. Here am I in the middle with the robe, and then my two supporters, I didn't choose other law lords. I thought that because I was a little bit different, I would like to have a man and a woman for a start, and I would choose academics. And Lord Flowers here had been rector of Imperial College, a very distinguished physicist and a great man. And this is Baroness O'Neill of Bengave, who is happily still with us, very distinguished philosopher and Reith lecturer and principal of Newnham College, Cambridge. Now, this jolly pair are in fact the current president and deputy president of the Supreme Court of the United Kingdom, but it's when we were still in the House of Lords, and I believe that it will have been on the day when we gave our last judgments in the House of Lords. Definitely we're in the House of Lords chamber because that's the red benches there. We gave 7 judgments, I think, that day in the House of Lords, because of course what we did when we gave judgment was hilarious. We would, the person who had been chairing the particular panel that had heard the case would get up and move that the report of the appellate committee be agreed to, and then says for the reasons to be set out in a judgment which I have prepared, copies of which are available in print, I would allow this appeal, dismiss this appeal, or whatever it was. And then one by one, the other members of the panel would get up and say, for the reasons in an opinion or a speech which I have prepared, copies of which are available in print, I would dismiss, allow the appeal. It was an amazing farce. Nobody knew what on earth had been decided or why. They had to read the judgments in order to find out. We do things completely differently in the Supreme Court, and it's one of the benefits of the move. But that's a happy recollection. I've been a first so many times in my life that it feels quite normal and natural, but that's normal and natural for my generation. There weren't a lot of women in the law when I started out in the law, so it was pretty easy to be the first. I was in fact the second woman in the chambers that I joined in Manchester, and I shall forever be grateful to the first because she didn't put the others off me or anything like that, whereas it hasn't been known sometimes for the first woman not to want to be joined by any more. I was the first from my school to go to Cambridge. I was the first from my school to read law, so just seemed normal. I was the first woman law commissioner, and I am completely relaxed about whether one of the reasons they appointed me was that I was a woman, and they were beginning to be embarrassed by the fact that they hadn't had a woman in the nearly first 20 years of the Law Commission's existence. I think I was the 10th woman to be appointed a High Court judge. And there were 6 of us when I joined. So we still felt a little bit outnumbered, invisible amongst that sea of men. And my very first judges' meeting, High Court judges, debated what the women should be allowed to call themselves. Mrs. Justice or Miss Justice or Ms. Justice or whatever. And it was the men, of course, who decided what we should call ourselves. And then the first woman law lord, which is much more significant, and that did feel really scary. I grew up in a village in North Yorkshire where my father was headmaster of a small boys' boarding school, and my mother, who was a qualified teacher, ran the boarding house. I was the middle of 3 daughters. We went to the local Church of England primary school, and of course it was in the days of the 11 plus, and not a lot of people from the school passed the 11 plus, but we did all pass the 11 plus, and went to the local girls' high school. I think there were 169 pupils there when I was there most of the time. That was, of course, half the number of places that there were at the boys' school. But it wasn't until much later in life that I realised the injustice of this, that they really didn't think that the rural girls needed educating in the same way that the rural boys did. Almost all the teachers who were teaching when I started at the school, I was the youngest girl in the school at the age of 10, were still teaching there when I left at the age of 18. And continuity is wonderful for learning and teaching. They were a bit fuddy-duddy and old-fashioned. Hardly any of them were married, because that was in the days when you tended to have to choose between marriage and a family. And in fact, I grew up thinking that's probably what you had to do. And that's because my mother was of the generation of trained women teachers who were obliged to give up work when they married in the 1930s. And that's why she wasn't teaching when my father became headmaster of this school. But it was wonderful that she was a qualified teacher, because when my father died very suddenly, when I was 13, she sort of picked herself up, dusted off her teaching qualifications, and became headmistress of the village primary school where my younger sister and I had been to school before. And again, looking back on it, what a wonderful role model she was. I mean, both parents were wonderful role models, partly because they believed in us girls. They wanted us to do as well as we possibly could. It was taken for granted that we would go to university, although at that stage only 5 or 6% of the population went to university, preferably Oxford or Cambridge, because my father had gone to Oxford and my mother's father had gone to Cambridge, so it was a bit of a battle at boat race days. But they gave us this amazing faith in ourselves and confidence in education. My headmistress did think that I stood a reasonable chance of getting into Oxford or Cambridge. My best subject at school was history, but she was a historian, and she said to me, "Well, Brenda, I think you ought to be going to Oxford or Cambridge, but I don't think you're a natural historian. Should we try and find something else for you to study?" And she said, "What about economics?" Now, I'd done economic history for A-level, and I hadn't enjoyed the theory very much, and so I thought I probably wouldn't enjoy reading economics at university. But I'd also done constitutional history, especially of the 17th century, as part of the history course. And so I said, "No, I don't fancy the idea of economics, but what about law?" And instead of saying, "Nonsense, girl, girls don't do law," or "they only do law if law's in their family," or "we don't know anything about law here and we don't like to encourage people to do things we know nothing about." Not sure she knew anything about economics, but that's by the way. She said, "Oh, what a good idea. We can't help you in any way, but, it sounds like a good idea." And as it turned out, it was a very good idea. There were 3 women's colleges and 21 men's colleges. So I think the women almost all felt, a deep sense of privilege that we were in this wonderful place, getting this amazing education. Whereas some of the men undoubtedly felt that it was their right to be there. They were the ones you wanted to punch in the face, but didn't, of course. I think it was only later that, again, one realised it was a built-in quota which discriminated against women. And of course it was wonderful to be there when the undergraduate sex ratio was so very favourable as far as we were concerned, so we could all have a jolly good time if we wanted to, and we did. I'd thought about going to the bar and had applied for a scholarship to one of the Inns of Court and had not got it and had not liked what I saw when I went for the interview. And people were still being put off going to the bar if they didn't have money or connections, and I had neither money nor connections. It was wrong to put people off going to the bar because almost anybody who went to the bar in the 1960s did very nicely, thank you, because that was when the work started to pick up and take off. But there was a certain amount of discouragement. I spent my long vacations working in solicitors' firms. One was in the local marketplace firm of solicitors that my parents had used. I enjoyed that a lot, and in many ways it would have been a lovely life to be a solicitor in Richmond, in a beautiful place, and making a decent living without having to overexert oneself. And another vacation I spent at one of the Magic Circle firms in the city, and they were kind enough to offer me articles, but I'm not sure whether they'd had a woman article clerk by then. But in the end, I decided I didn't really want immediately to go and do the solicitor's exams because I had worked hard for my Cambridge exams. And I wasn't really attracted by the city. Something about the atmosphere that I didn't quite like, possibly being a country girl, I don't know. So I thought, what about teaching, law teaching? Because by then, I was getting very good results, and you could, at that stage, get a law teaching job without a postgraduate degree. Can't do that now, but you could then. So I applied to Bristol and to Manchester for assistant lectureships. Manchester I chose for two reasons, one of which was they had famous professors who'd written books that one read as an undergraduate. So it was intellectually a very stimulating place. And they wanted me to qualify as a barrister and do some part-time practice at the bar. I was very lucky to be offered a pupillage in what was a good set of chambers. And I was pupil to a very senior junior barrister at the Manchester Bar who became a circuit judge just at the end of my pupillage. But I was told that he didn't approve of women at the bar. So halfway through my pupillage, I plucked up courage to ask him, why, I've heard you don't approve of women at the bar. Yes, he said, that's quite right. Well, why? I said, your wife's a doctor. Ah, he said, well, medicine is a caring profession, and women should, of course, be carers, but the bar is a fighting profession, and women shouldn't fight. What's more, he said, they don't know how to. They're either too stubborn or too yielding, whereas at the bar, and indeed in litigation generally, you do have to have the judgment to know what to fight, how to fight it, and what to settle if you possibly can, all of those various things. I thought it was a fascinating conversation, because he was right about the bar. He was wrong about the stereotyping of women, of course, he just hadn't met enough of them, or else he'd got rather rigid views. But he was right about what it took to be a good barrister. So I reflected quite a lot on that as to whether I did have what it takes. After I'd been in practice for 3 years, I was basically put to my election by both chambers and the university. Chambers were at that stage splitting up. Some of the very best people were setting up a new set of chambers with some other people from other sets of Manchester chambers. And the leader of the breakaway group said to me, well, Brenda, we'd be very happy to have you with us, but you'll have to come full-time. And the university, of course, was saying, it's about time you published more. Because obviously as an academic, you don't just teach, you have to research and publish as well. So I had to choose, basically. And I chose the university for 3 main reasons. My then husband was also at the Manchester Bar, starting out same time as I was. We had narrowly avoided being on opposite sides of the same case, which can happen because you don't get your briefs until late afternoon, early evening. And we thought that it would be a good idea if one of us had a salary, because however modest university teachers' salaries are, at least university teachers do get paid, whereas barristers can take a long time to get paid, even for the work they've done. And of course it can take quite a long time for the work to come as well. It didn't, in fact, with my husband. He was very successful very quickly, but that was one reason. But the main reason was much easier to combine having a family with university teaching than with practice at the general common law bar. So I made that choice, and a year or two later we had a daughter. My daughter says that she remembers going to sleep when she was a child to the sound of my typewriter. So she, of course, grew up with a working mother. I went back to work when she was 3 months old. She will, of course, have lost out on some things, I'm afraid, but she always had the model of a mother who worked in the university. I wrote a book about mental health law because I was teaching mental health law, and that got me my first judicial appointment as a presiding legal member of mental health review tribunals. I started a journal on social welfare law, and that got me appointed to the Council on Tribunals, which was then the supervisory body for tribunals. Something that I was doing got me invited to become an assistant recorder. That's, Crown Court judge. And I think it was those sorts of things. They knew about me by then. And then another book that I wrote with a colleague probably prompted the Law Commission. So it's all of those sorts of things that I did while I was an academic that led to the public service career later on. In the Law Commission, we were looking at the law relating to children as between parents, not as between the state and parents, but as between the parents themselves. And we produced recommendations about that. Again, the law was in a terrible mess, and so we wanted to tidy it up and make it coherent and principled. And the really great good fortune was that we were able to legislate for both of those projects in the same Act of Parliament, which meant the whole thing was neat and tidy. Everything was in one place. It all hung together as a structure of principles and remedies and so on. So that was the greatest thing. But I have been pleased about how the individual interests of children have become much more prominent in legal decision-making over the last decade or so. And I think I have played a very considerable part in that, one way or another. It hasn't been difficult. It's often been one of these things where you only have to say something, for the others to say, oh yes, that's got to be right. There was also a case which had to do with women having babies that they should never have had because either they or their partner had been negligently sterilised, and how one looks at having a baby that you never meant to have from a female point of view is, of course, very different from a men's point of view. That's a very obvious example. Probably looking at how you assess the ownership of the family home. Again, that might be an obvious example. Another obvious example is how you assess the pressures that lead people to agree to prenuptial financial agreements. Again, that might be something where women have a different perspective from men, or some women have a different perspective from men. There's a wonderful book called Feminist Judgments, which takes some famous cases from all round the law and rewrites them from a feminist perspective, using the tools and the evidence that was available at the time, so doing it honestly, but reaching either a different conclusion or the same conclusion for different reasons. And this goes across all sorts of areas of law. Yeah. There is a feminist perspective on most areas of law, I am told. I'm definitely a feminist because I define feminist as being somebody who believes that women are the equals of men, and that their experience and perspective is as valid as the perspective of men. And I think that's a sort of soft feminism, obvious feminism, really. A lot of men would say exactly the same. I mean, you can be a man and be a feminist, and you can be a woman and not be a feminist. But I'm not the sort of feminist that doesn't like men. Or value them and their perspective. It's equality I believe in. There are lots of reasons for wanting a more diverse judiciary. And of course, we're not just talking about gender, we're talking about ethnicity, we're talking about professional background, we're talking about social, economic background as well. All sorts of dimensions of diversity. But number one reason is legitimacy with the public. I don't think the public any longer take to a situation where the law is being made or their lives are being judged, really important decisions that may affect them for all their lives are being taken by a narrow section of society. The courts should be much more reflective of the whole of society. I think that's number one. Number two is, think of all those able women lawyers there are out there who've been qualifying in equal numbers to men for decades now, and we're wasting all their talent by not recognising it and appointing them. And that is because we tend to look for appointments from this comparatively narrow pool of barristers. A third reason is that it's symbolically bad. You know, the law is supposed to be about justice, fairness and equality. And it doesn't look very fair and very equal when the judiciary don't look very equal. And then the final reason, of course, which is much more controversial, is does it make for better judging as opposed to a better judiciary? And that's very hard to answer. But I do think there are some things that women can bring which wouldn't be there or aren't there as strongly as they are when there are women around. It's almost as if our absence is more important than our presence, because the presence can bring something, but it's the fact we're not there that matters quite a lot. And there are different perspectives, because, like it or not, women lead different lives from men. We don't have any choice in the matter. And that perspective, coming from the life that we lead, is just as valid and just as important in shaping the law and doing judging as the men's perspective.